I terminate the probation.
Yes, sir.
Once we get the restitution, there's no reason to keep you on probation.
I'll pay that right. I'll take it. I got John suspended. This is
Hey,
something. I
hold
told
on.
him to give him the full agreements.
Hold on,
Months
Tex.
ago, he ain't doing that
Hold on.
for me, man.
That's not on here. That's not what you have. That's not. Mr. Green probably has more. I think Mr. Green has more indictments than anyone on my docket historically ever. Which is, I guess, for some notoriety. But okay, on this one, who's on this one? Which case carries with it the most punishment?
Judge, there's been a couple of times where we've gone through this, and one of these cases is mislabeled.
Okay.
He has a failure to register as a sex offender. One of the theft state jails is actually a registration offense. And that and the assault public servants carry the highest punishment.
Over here.
Yes, sir.
God bless you.
I want to speak to you, sir, because you fired him like 5 times doing this view.
It's good to see you.
Yes, sir.
All right. We've got 22 cases here.
Yes, sir.
Okay, we got
22 cases. Let that sink in for a second. Most defendants walk into court worried about one indictment. This judge is staring at an entire stack, like he's sorting mail. And notice the judge's tone here. Calm, almost patient, but also incredibly deliberate. That usually means the court already knows this hearing could spiral at any second. And honestly, the moment a judge says this is not the kind of prize you want to win, you already know this defendant's reputation is walking into the courtroom before he even speaks. Question for viewers. At what point does a court stop seeing...
Take them.
So, yes, sir. Go my bad. Go ahead, Judge. My bad. Yes, sir. Yes, sir.
So we got to be deliberate here.
Yes, sir.
That's a lot. And like I've said before, this is the most cases any defendant has ever had before me since I've been here for almost 20 years.
Yes, sir.
Which is not the kind of prize you want to win, you know?
Right.
So you got, it's hard enough to fix one. Now you've got 22, and those need to be deliberate, responsibly dealt with.
Yes, sir.
All right. You've got a bunch of thefts here, and then evading arrest, another theft.
I never did evade arrest, sir. Go my bad.
This is what we're charged with.
Yes, sir. Yes,
this
sir.
is in the trial.
Yes, sir.
It's in the debate. Okay. Then two assaults of public servants. I guess those are going to be the more serious.
Yeah, I got beat. I don't know what got beat. I had 2 black guys in the factory.
You know what? We're going to.
This is where the courtroom dynamic starts changing fast. The judge is trying to sort through actual charges and punishment ranges, while the defendant keeps interrupting with emotional outbursts and side stories. Legally, that matters more than people think. In plea negotiations, judges watch behavior closely, especially when someone is facing assault on officer allegations. And the timeout like kindergarten line, that's the judge trying to regain control without exploding. It sounds humorous, but underneath it is a warning. Stop.
We're going to put you in timeout like we
yes, sir.
we had to when we were in kindergarten.
Yes, I'm sorry. I'm sorry, sir. I'm sorry.
Don't do that.
Yes, I'm sorry.
Judge, let me correct the one that is mislabeled. It's cause number 41332. That is not a state jail theft.
What is it?
Failure to register.
As what?
Sex offender.
Okay, the most serious cases, I guess, are assault of public servant.
Along with
Is that the
registration offense. Those
and
are all
what's the degree punishment for those?
third.
They're third degrees. Okay, so you got, oh boy.
Miss Bob.
Miss Bob, my God, God bless you.
Feel the spirit.
Yeah.
Feeling something. Yeah, that's Miss Bob. I'll add some things.
Did you, was she doing that? Hey, Henry, was she doing that earlier?
No, sir.
No. Wow. And she's got to run out of gas soon. You just lose your voice.
And I got the sort of I got him chatting. I got him suspended for 30 days for him not feeding me. March 2022. I got the grievance number and everything. I'm trying to give it to him. I'm trying to give it to him so he can pull the grievance.
Wait, last year?
Yes, sir, 2022. And then
that's 2 years ago.
yes, and then June the 6th, I come in from rent. He told me I was compensating myself. So I went to the front in the day room. I said, please call rank, sir. He didn't call rank. He picked me up, hit me out. The moment they hit me over 100 times in the face. Him and beads. Lieutenant Ford had to come from the box.
What happened? Did they send you to the hospital?
No, sir. I had 2 black eyes and fractured jaw, though. I had 2 black eyes.
Fractured jaw?
Yes, sir. My jaw was fractured.
Did it heal itself over time?
Yes, sir. Yes. It's not, I know if I open my mouth over 30 seconds while I can't get pop out of place. Nigga talk about I ain't even saw nobody. I beat his arms because he been out first.
Well, here's the deal: is that the grand jury
yes, sir.
indicted you,
yes, sir.
and they heard some evidence.
Yes, sir.
On the other side of the coin, are you guilty or not guilty? Not guilty,
right, not
because
guilty.
of the presumption of innocence.
Right.
Okay. You got that going for you.
Yes, sir. A criminal episode.
But let me look at these assaults here. What we're looking at, because they seem to be the most serious. What, Henry? Where are you still living on 15th?
Yes, sir. Thank you, my brother.
Oh, you got some notes?
Yes.
All right, let's learn. There's no any chances.
Go check that out. I got music combat. That's what they call music combat. And I got cases, my log numbers on there. I got jumped on by the law.
This says you bit an officer on the arm.
Yeah, and he hit me now. He hit me. I was handcuffed, sir. He hit me now until my leg on the fence. I jumped up when the yank go up off the ground. I was sitting down.
The other one here is you kicked the officer in the legs and the groin.
No, that's a lie.
That's got to sting.
That's a lie, sir. That's a lie. I never kicked. That's a lie. He tried to cover that Jones. He said I kicked. Never kicked.
Now, the conversation shifts into something courts deal with constantly: medical issues, jail time already served, and whether someone is actually capable of re-entering society. You can hear the defendant throwing everything on the table: cancer, family illness, injuries, promises to change his life. But here's the uncomfortable reality. Judges hear promises every single day. The legal system doesn't usually move on emotion alone. It moves on evidence, history, and risk. What makes this scene tense is that the judge...
He be over in the cell over on the time. I had 2 black eyes and a fractured jaw. And I told mom and dad to call you to see if I turned the fast, showing you the picture that Lieutenant Wolf posted, took a picture of me and started to turn the fast, and turn fast part, showing the picture. And then that's go by.
Okay.
By the room.
Here's what you. How long have you been in jail now?
21 months this month, sir.
21
months. And I got cancer and everything, sir.
Yeah.
I got cancer. My dad fight prostate. My dad had mini stroke. Nothing like so. He had mini stroke, and my dad fight prostate cancer. So if I come back, you can.
How are they treating you on the prostate cancer? What are they giving you?
No, my dad fight prostate cancer. I'm telling you,
it's your dad.
If I come back for you, let me go home day, sir. If I come back for you, get 25 life. Now I'm signing right now. I agree. I'll take 25 life. Come back.
Well, it's not the. You can't be making deals with me. You got to go through.
I'm not gonna come back. I'm telling you, I got my life. I'm gonna go back. I'm gonna take advantage of the Joe Biden rent and go to school.
So, how do we want to deal with Henry so that he can move on with his life one day?
Judge, he's been found competent, I'm pretty sure, Judge.
That's a while back. Like the judge, I did give Mr. Green the offer of the 5 years TDCJ on to solid public services.
Well, how much does he?
But he's saying that he won't.
How much does he have credit for?
He did tell me he would take time served. He told me he would take time served.
You take time served. Yes, sir. Time served. I'm like you.
406 days.
What was the offer?
He did tell me he would take time served on all these cases.
What was the offer?
Oh, I'm sorry, Judge.
Yeah, nobody told me.
I'm sorry. The offer in this case that I gave to him was on death cases, probation 2/5 plus restitution to be determined in the probation.
Were you gonna, if you were released, where are you going to work so that you can pay some of this loss back?
My brother, president of the Port Authority, sir. My brother, president, and he been working this since like 9-5. My brother, President Benjamin Green. You could bump pay my other brother.
How much would he pay you?
I make $20 an hour, and plus I got a feather on the way. I had a part of the rest. Look at it, I got two in my head. You see that right there, back in the head, sir?
Oh yeah. Did Mr. Kimber do that?
I got tumors in my head, my leg, and my chest, sir. Oh, he's right. I need to get by. I went to Galveston when I got out last time to the emergency room. I went back. They told me about with an appointment. They probably got me biopsy so I could find what kind of cancer I have.
And how did you get hurt?
Cancer. I had to fall. But my lawyer,
while you were at work?
No, sir. At the restaurant, my lawyer took for $1 million. And that been March 2021, 17. March
So
17.
where did you fall?
At a restaurant in Port Arthur.
So what did you slip on? Did you slip on something?
It was the water. The floor was wet and it was greasy. I was slipping fell. I tried to grab a trash can. I slipped and fell.
So what's the offer that y'all?
I'm sorry, John.
Yeah, let's get back to that. See, practically, what was it?
Judge, it's the issue is that we've offered TDC time on some of his higher charges. However,
This might actually be the most important legal moment in the entire hearing. Listen carefully. The prosecution is explaining a blended resolution. Prison time followed by probation and restitution. That's the system trying to balance punishment and accountability. And surprisingly, the judge seems open to it. He's even calculating parole eligibility out loud, almost guiding the defendant toward the safer option. That's rare. But here's the problem. Complex plea deals require clarity, focus, and
there would be a consecutive probation where he would be put on probation after he was released and have to pay his restitution. Because it's a mixed bag of everything, and we've got to, accomplish
what's the flat time?
Flat time was 5 years TDCJ, and he told me he wouldn't take it on.
Well, he's almost done it now. He's almost
quite close.
He's almost fulfilled that, and then we could get him. I don't know how. You may have to spend a little more time. But that's not for us to decide. But it sounds like you're eligible probably toward parole. Then the other agreement that they would put you on probation for a period of time so that you can get the money to pay back for working or whatever it is you're going to be able to get them. And on cases like that, once people pay the restitution, I terminate the probation.
Yes, sir.
Once we get the restitution, there's no reason to keep you on probation.
I'll pay that right. I take probation, pay it off. So my lawyer told me so I get out. I'm on the phone.
Well, you don't have the money with you right now.
He was $470 from that day. He can write my check to me. It's supposed to be $54,000. Yes.
Are these affirmative? There are no affirmative findings on these assault on police officers. So he gets paroled in a quarter of his time, right? On 5 years, a quarter of a time.
He's eligible.
He's
eligible. His good time is flat time equal 25%. That's just eligible.
And he's been 22 months.
He was probably already.
See, he'd probably be. You need to think about that. You'd probably be eligible for release on those, then put you on probation, get you out, and once you pay, well, that's important. You'd have to admit that. You can't do it. All right.
And then I got people retaliating on. That's a felony.
I don't see that.
And there it is. The entire hearing suddenly unravels. One misunderstanding about who was actually indicted flips the atmosphere instantly. Up until now, there was at least a possibility of negotiation. But once confusion enters the record, judges often pull back and default to trial settings instead of risking a bad plea agreement. That's why courtroom procedure matters so much. One missing clarification, one misunderstood charge, and suddenly everybody's strategy changes. You can almost hear the frustration in the room the second the judge...
It's a fair retaliation. I got the grievance number right here. Look.
No, you don't. I don't have that. That's not filed against you.
Yes, I got the grievance number right here. I got John suspended. This is the grievance number. I told him to give him the pull agreements.
Hold on, Tex.
He ain't doing that for me, man.
That's not on here. That's not what you have. That's not been...
Everything unravels in real time. What started as plea discussions quickly collapses as the judge decides the assault cases will head straight to trial. No deal, no shortcut, just raw courtroom pressure. The big question now, was there ever a realistic path to resolution? Or were these charges always destined for a jury?
Not been indicted. You hadn't been indicted for that.
Assault officer, he had been indicted for 2 assault
2
officers.
assaults.
And then Jones was one assault.
You were talking about something else.
I'm talking about Jones. He assaulted me that day. I got him suspended for not feeding me.
So,
He retaliated.
oh, he was the victim.
Yeah, I'm the victim. I'm a victim of retaliation.
Well,
And then,
have they filed that on somebody?
My wrist, man. I was the handcuffed for 14 hours back then. In March 2019.
Okay.
And the rap for 14 hours.
Here, we're not getting much done now.
Yes, sir.
Okay, I understand things. Here's what we're going to do: is the assaults on public servants. We'll just set those for trial. That's what we have to do. If we can't work it out, we'll get these things as soon as possible, and the others are just going to have to wait. But we'll get it for trial. Okay,
Yes,
that's
sir.
all we can do.
Yes, sir. Check out me, get a new lawyer.
Yeah, no, Langston Adams is a very fine lawyer. You can hire anybody you want.
You fired him 5 times ago. You fired him literally 5
I
times
didn't
ago.
hire him.
Come on,
No,
look at the paperwork. You fired him 5. You know this. It was here 5.
I'm sorry.
You fired like that. In fact, this is the Kansas. I told you that.
The way
And this ending says everything. No dramatic resolution. No emotional breakthrough. Just a courtroom exhausted by conflict. The judge stays procedural. The defendant stays angry, and the attorney-client relationship completely collapses in public view. Legally, the judge is correct. Defendants don't automatically get a new court-appointed lawyer just because communication breaks down. There has to be good cause. But emotionally, you can feel the defendant believing no.
it works is that once you have an appointed lawyer, the indigent commission says that you have to keep that lawyer unless good cause is shown to replace him. And Mr. Adams is a very vigorous advocate for his clients.
Hey,
I
sir.
know that.
You can look at the paperwork. 5 times. Look, I see you jot down your paperwork. You told me you can hire me a new lawyer. You say you.
I'm not going to hire anybody.
And this came out your mouth. You said you're gonna hire me a new lawyer, and I'll be back in your court. I'll be back in your court faster.
Why would I do that?
Because we would get along. We
Well,
gotta get along. He not doing nothing for me, man.
Just because you don't
He
get
not doing nothing
along.
for me. In fact, this is the council.
Look, this isn't a date,
I know.
and you're not married to somebody.
It's in fact.
This isn't
the
a
council.
divorce.
I feel like he not doing nothing for me. He not doing nothing for me.
I know him to be a very vigorous advocate. But you're in jail when he's doing the work for you.
He didn't even let me see the tape. He didn't even let me see the side out the tape. He didn't even see the side out the tape.
His mama and dad were in my office, and we watched the video of the incident. And I
Well, he wasn't there because he was in jail.
Yeah, he was
Okay.
But the mom
What?
and dad was in my office.
Hey, let me see. Why you let me see? Why you let me do the camera? Why you let me do the take offs? You ain't doing nothing for me, man.
I'm going to set these assaults for trial, okay, and get those as soon as possible. That is all, Henry.
He just told me he want to be on my case before I came in here. Come on, Mark. He just told me he want to be on my tape.
He may not enjoy representing you, but that's not the test. You can hire anybody you want.
I got one of the best.
What do you?
It's like that. Courtroom falls into procedural silence, trial dates ahead. Emotions still boiling, the defendant stuck between multiple cases. A fractured legal strategy. One judge, 22 cases, and a system now shifting from negotiation to full confrontation.